think you should be live now.
Okay. Good morning. This is Tuesday. No, it's Wednesday already. God, time flies when you're having fun. It's Wednesday, February 10th, 2021. And this morning we are taking up a bill on probation. Bryn Hare is the legislative counsel who has done a rewrite of the bill, and it can be found on the committee webpage. It is S45 and is part of the Justice Reinvestment 2 initiative. So with that, hand it over to Bryn. It's draft 1.1, 29/21, 11:08 a.m., I believe. Is that the one we're talking about?
It is.
Good. All right. So there's a bunch of yellow stuff in section 1.
Yep. So good morning, committee. For the record, Bryn Hare from Legislative Council. So I just wanted to preface walking through the changes in this amendment by saying that I think that this draft really reflects like the first crack at pulling together some of the threads that this committee was talking about in its work on this bill last week. I didn't manage to get this draft out to the witnesses until yesterday afternoon. So I didn't have the opportunity to incorporate any feedback of theirs into this draft. So I anticipate that the witnesses will have quite a bit of feedback. I myself have some questions about how this would work. So I just really want the committee to take this for the first draft that it is.
Okay.
So
or today in Vermont.
I didn't hear you, Senator Nitka. Will you say that again?
I should have been muted. I was trying.
Oh, okay.
I'm sorry. Okay.
Okay.
I was just trying to get a copy. I was just trying to look on my phone to get a copy.
Oh, yeah.
Would it be helpful if I put it up on the screen?
Probably, yeah. Would that be
Okay.
helpful? If somebody has a question, I may not see you, so just shout out. And as well as those in the audience who are invited to discuss drafts as we mark up bills.
Okay, so let me share my screen.
It's not sharing. There you go. All right.
Can everybody see that?
Yep.
And if I scroll, can you see it scrolling?
Yes.
Okay. All right, great.
Just
So as we always do, I put the changes in yellow here.
mhm,
So I'll just walk through those yellow portions.
please.
And the first change that you see in section 1, this new language in subdivision B 1 and 2, this was a recommendation, or this was some suggested language that was given to me by Judge Grierson. And so the change here provides that the sentencing court, this language directs the sentencing court to automatically discharge at the midpoint unless the commissioner seeks a continuation of probation and the court finds by one of these standards of evidence, either clear and convincing evidence or a preponderance of the evidence, that's for the committee to decide, that either one of these factors is true in A or B. Termination and discharge will present a risk of danger to the victim of the offense or to the committee, or that the defendant is not in compliance with the conditions of their probation.
Bryn,
Yes?
just a question. B1 begins with the commissioner recommending, and then one of his options is not to recommend, but to seek a continuation. It seems like there's a, do we really need, I don't know how to put it, but he wouldn't recommend if he sought a continuation?
Right. So I think this is one of the little language tweaks that need to be made depending on how the committee comes out on this issue. In 252, then section 2, that's where the directive to the commissioner lies for filing the motion to either discharge the person from probation or to reduce the person's term of probation.
Yep.
So I look forward to hearing from the witnesses and figuring out how exactly these directives work, whether the commissioner is required to file, and then the court, based on the commissioner's recommendation, is required to discharge, or if the court is going to discharge unless the commissioner files a motion to continue the probation. So I think there's a little confusion in this draft about the commissioner's directives and the court's directives.
Yep.
And I'm hoping that some witness testimony will give me some more direction on this.
Okay. Thank you.
So I wanted to highlight a different section here that we'll have to decide whether it's clear and convincing or preponderance of the evidence. But in B, the defendant is not in compliance with conditions of probation. And then over on page 6, on line 7, we have C, which is has completed any determinate period of rehabilitative or risk reduction programming required as a condition of probation, and completed any indeterminate period of programming to the satisfaction of the probation officer. I think that should be added to, a reference to that should be added to B, because if the only reason the person's, it sounds like is not in compliance, would they not be in compliance if they haven't completed programming? So maybe they're, were sentenced to a year of probation and their programming takes 9 months. So I don't want it to look like they're not, so if there was either a refer back there or somehow loop that back in here.
Okay.
Because it looks terrible if you're not in compliance with conditions of probation, but it may be you're not in compliance because you haven't completed program.
Right. You've just identified another kind of question I had about this version of the draft. So I do hope that witnesses will weigh in on that piece as well.
Okay. Well, we keep walking through. But,
okay.
So
B2 is the next piece of recommended language from Judge Grierson, and this would provide that if the court, if the commissioner filed a motion to continue probation, the court has these options. The court can continue probation for the full term or any portion of that term, and the court can also modify the conditions for the remainder of the term.
Mm-hmm.
So now I'm gonna, okay.
I'm gonna complicate this a little further too, back to my, they could modify the conditions of probation in terms of completing the treatment if, let's say one of the conditions of probation was you shall attain your GED, and it's just been determined that that's impossible for this particular individual, given their educational background or whatever, that they would never be able to do it within a reasonable amount of time. Would that be an ability to change that condition or allow them to be discharged?
Right. I think the way it's set up now, it sort of gives the court the discretion to change conditions as it sees fit. It's not really based on anything as it's drafted now.
Could it add conditions though?
It looks to me like it modifying conditions. I think that language is pretty broad. So it looks to me like it could.
I think Senator Benning has a comment or question.
Yeah, that was my concern, was that this is the court may modify on its own decision without anybody petitioning for a modification. I find that a little bit troubling.
Okay. So I'll make a note about that.
Yeah, I agree with Senator Benning. I'd hate to see them adding things in without any.
Yeah, keeping in mind that probation came about as a result of a plea agreement or a sentencing. And I get a little leery without somebody petitioning the court that the court could actually take it upon itself to just change whatever the original sentence was.
Okay. So we keep going?
Yep.
So I'm gonna skip down now to page 6, we're in section 2 now, and remember, this is the subsection D is the directive to the commissioner to conduct this midpoint review.
Mhm.
So we've got some changes here. So these are the circumstances under which the commissioner shall file a motion requesting a dismissal of the probation term. If the offender hasn't violated the conditions, that's A. B is the new one. This is the language that carves out certain crimes. So the commissioner shall file a motion for discharge if the person is not serving a sentence for either committing a listed crime, that's 13 BSA 5301, or there was also some talk about other more specific crimes rather than the whole list of listed crimes. So I put in 13 BSA chapter 19, subchapters 6 and 7. Those are the domestic assault crimes and the stalking crimes. Or 13 BSA chapter 72, subchapter 1, and those are the sexual assault crimes. I will note that this doesn't include L&L with a child. That's a separate statute. So depending on where the committee wants to go with excluding certain crimes, we may want to get more complete here.
To me, what crimes we add here determines for me what I choose in whether it's the clear and convincing or preponderance. So for example, for me, if you included L&L with a child, which usually then I might consider it being clear and convincing because they wouldn't be eligible, correct?
Correct. If you included that here, then they would not be eligible.
Yeah, but if I don't, then I might want to go with the other preponderance. It depends on who's included in this group of people who are eligible for this midpoint review or midpoint dismissal. Me, and I'm happy to hear witnesses comment on that after we finish the walkthrough of this draft. I think all of this is connected. The things on page 6 are clearly connected to the decisions we make on page 1.
Right. So the language in C is also different. So this is what we've put in to try and address the issue of indeterminate programming. So this puts in a requirement that the probationer has completed any determinate period of rehabilitative or risk reduction programming that's required as a condition of their probation, and that they've completed any indeterminate period of programming to the satisfaction of the probation officer. I know you heard from some witnesses that they didn't like this language. I put it in with the following sentence as a way to kind of address that concern about having only the probation officer making that decision, which is that the probation officer shall maintain sufficient records so that the determination of the completion of an indeterminate period of programming may be reviewed by the commissioner and by the court. If you decide to go with that, I think we need to put in some specific language in section 1 directing the court to actually review those records of the probation officer. I just didn't know if this is the direction the committee wanted to take, so just a note there that we should put in some more language if you do want to go this route.
Yeah.
And
As
then
much as possible, I don't want to have differences in either probation districts and how they do things or probation officers and how they do things entering into this. I want as much as possible for it to be pretty clear. I tell you a brief story. And years ago, and this is over almost 40 years ago, there was a kid in the program, and his probation officer was on vacation, and the kid did something, I don't remember what, I wasn't there, and they called over probation and parole, and the kid put a bureau up against his door to not let the probation officer into the room. So the probation officer called the police, broke down the door, dragged him off to jail on a violation. This is a long time ago, but long story short, Marty's probably been one of the most successful kids that ever completed the program at 204, notwithstanding what one probation officer did in a really unusual circumstances. And it just worries me when we give that much latitude to individual probation officers to determine these things. I'd like to have it pretty clear cut.
Okay. I'm going to keep going. We're just about finished with this draft.
Okay.
So subdivision 2 is the language that directs the commissioner to file a motion to request a reduction in the term of probation. And
Yep.
again, I think here we might need to get more specific, whether you want to require the commissioner to file a continuance of probation, or if you want to allow them the discretion to request a reduction in term if the probationer doesn't meet the criteria for eligibility listed here in subdivision 1.
So can I just ask a question about that? So for those persons, would a person who's on lifetime supervision be included in that? In other words, that they could make a request to get that person out? I know at one point we were talking about not having the people on lifetime supervision included in this.
Right. So this is really the people that are serving a specified term.
Oh, okay. Well, lifetime.
Shall review, yep. Yeah, the language here provides that commissioner has to review everybody serving specified term. So I think I would let the witnesses weigh in on that, whether that would be considered a specified term or if it would apply to those people.
Okay.
So I'm going to move on to subsection 3 here. So this is that language that provides that if the commissioner doesn't file a motion to discharge in accordance with subdivision 1 or a motion to reduce the term as provided in subdivision 2, or if the court denies the commissioner's motion, then it requires the commissioner to conduct a review upon each point that the probationer completes one of their conditions of probation. And I think that was a suggestion from the department. So that's new language there. And then it provides that if the probationer meets those criteria that we talked about in D1, the commissioner has to file a motion requesting dismissal. And if the probationer is ineligible pursuant to those criteria, then the commissioner can file a motion requesting reduction in the term. And then lastly, the new language in subdivision 4 directs the commissioner to make a good faith effort to notify any victims of record about any motion that's filed to reduce the probationer's term pursuant to this subsection. So I imagine you may hear some comments on that victim notification piece as well.
Yeah, well, why don't we try to, are there any questions from the committee? Might be a good idea if we could hear from some of the folks in the room with us. I don't know if it's what you call this, is it a room? Judge Grierson.
Yes, good morning, Senator. Good morning, committee, and thank you for the opportunity to speak on S45. For the record, Brian Grierson, Chief Superior Judge. And I apologize for not being able to talk with Bryn last night about the draft. The first section, she's right that I did make suggestions on that. And the suggestions I made, well, let's put it this way. They're not, the way the draft reads is not what I had proposed. So there's no question there are issues in there. One of them certainly raised by Senator Baruth that needs to be corrected. What my suggestion was, and I don't know if any of the other stakeholders agreed with it, was at the midpoint, it basically, the default was that the person would be discharged from probation unless the department moved to continue the probation. So the way it's written now, it definitely needs to be changed, and I'll be glad to work with Bryn on that. But if you look at the language where it talks about, you could leave it as upon the recommendation of the commissioner pursuant to 252. And I believe that's the way the department would like to proceed. The court shall terminate the period of probation, discharge the person, unless, it shouldn't be the commissioner at that point. It would have to be the state that is opposing the discharge, and they would then carry the burden, whatever burden the committee decides is appropriate. So that by just changing the line that says unless the commissioner seeks a continuation, it would be unless the state or state's attorney seeks.
Okay.
I think that would clarify it, and that I think that would be consistent with what the department would like. When you get into the conditions A and B, I think that's consistent with an earlier draft, not in compliance with the conditions. I would agree, Senator Sears, with your comment about linking it to the latter part of the bill. The conditions of probation could include the rehabilitative portion of the sentence. So I think that language could be clarified. The idea in granting the motion, it would essentially be, at that point, if the commissioner is seeking a discharge, it wouldn't be their motion that would be granted. It would be the state's motion to continue probation. So again, that would have to be clarified. Then this authorizes the court, or allows the court to modify the term of probation at that point, obviously reduce it, and modify the conditions. What I had in mind, and I would agree that that language is not clear, it's not to add conditions. It would be to reduce conditions that perhaps they've complied with conditions, and remove those so that it only leaves if probation is not discharged. The idea would be that the person would continue, perhaps for a reduced term, if it made sense, and on reduced conditions, because they've complied with them and they're no longer necessary. That was the idea behind that section.
Yeah. I mean, I can see somebody that has the interlock system that driving and then maybe no longer needs that.
Exactly.
And you take that off the probation, but continue their whatever.
Right. Yeah, the purpose was not to add conditions, but rather to, as we're going forward, reduce eliminate what are then hopefully unnecessary conditions that were appropriate at the time of sentencing, but because of compliance, they're no longer necessary. Hopefully that clarifies where I was.
Sorry, Senator Benning.
Judge, I just want to make sure the way it's worded now says that the court may modify the conditions. I understand that if there is a reduction of the conditions, but leaving it to modify suggests the possibility of additional conditions.
No, I agree, Senator.
I know what your intent is. I just want to make sure that whatever the drafting language ends up being, that we are all on the same page, that additional conditions can't be added. Otherwise, you're interrupting what was a plea agreement, and that means that the defendant would be entitled to withdraw their plea.
No, I agree 100%, and that was not the intent. And as I said, I'll be glad to rework that.
Yeah, I think
with
something
Brent,
like that may reduce or eliminate conditions,
or remove conditions that are no
or
longer
remove,
necessary.
or whatever the language is, to make it clear you can't add
Right.
a new condition that you go to Texas and work on an oil rig.
Right. So that was my attempt, but again, I'll be glad to work with Bryn or any other folks to discuss that language, but as written was not what I had in mind.
Other comments? Any other comments on the redraft, Judge?
I don't think so, Senator. I'll listen to the witnesses, and if
Yep.
something occurs to me, I'll let you know, but I was focusing on that section of the bill because of the
Might be a
court's
good
involvement.
time to hear from either Dale or Monica
Thank you.
if they're ready. From the Department of Corrections.
Can you hear me?
Yeah.
This is great. For some reason, my video says it cannot start.
Well, we can hear you loud and clear, Dale, so we can give it a try.
Okay, I don't know. I understand why. Hi, for the record, my name is Dale Crook. I am the Director of Field Services for the Vermont Department of Corrections. What the judge just said, we're kind of in agreement with that first section. The only additional thing that we'd recommend is at the beginning of B1, upon the recommendation, it really should be when a motion to discharge is filed by the commissioner, because it's not so much a recommendation as it's following the statute laid out in previous parts of the section. We do agree with the judge that the commissioner should not be the one seeking a continuance. That is kind of not our role. I think the judge laid that out well. Another concern that we have, and in a practicality, I think Judge Gersten kind of hit on it a little bit, is reducing a portion of the time. This will be also carried on in further sections. It really sets up some concerns. It's not very practical. And also, I think what Senator Sears mentioned earlier about having different standards from the POs across each office, it would set that up. I will talk about the reasoning behind that later, farther in this section. As far as the criteria, A or B, below that, it's really a policy choice. The rest of that section is fine. Then we move toward the end of the bill on page 6. As far as B is concerned, I think that's really a policy decision. Currently we have a may in our current rule, and in that may, through the rule process, we eliminated sex offenders being discharged. But that is really, the department can make any of that criteria work. It's really what the committee feels comfortable with, or what other witnesses feel comfortable with as far as the policy decision on that. As we move to C on page 6, I would recommend that we change that first sentence. Instead of risk reduction programming, that we change it to risk reduction services. The department operates risk reduction programs, and I wouldn't want that to be confused that it had to do that for a discharge. There could be other risk reduction services out there, mental health, substance abuse, anger management, that is not operated by the department. I think it meets what the criteria of what the legislation is trying to look for, but will reduce confusion on the departments and everyone that works with the department on that area. On the back end of that section, this is different. This is, I think I understand what Brent was trying to do here. We could probably strike out the commissioner, but really this is just documentation. This is case documentation that we have, and that information or evidence, so to speak, would be brought if there was a motion to object to our recommendation for discharge. The commissioner doesn't need to review that. The probation officer operates through the authority of the commissioner. So just strike out the commissioner. That other language is fine. We keep case documentation, discharge summaries from treatment providers, etc. That's not a burden. On line 13 on page 6 and number 2, this is where I start talking about the partial reduction. In practicality, it doesn't work out well on a few different reasons. One, this really should be the court determination to reduce the term. They'll at a hearing, it won't be a probation officer saying he's completed 3 out of 4, so I'm going to reduce his term 25%. While someone else could say, well, this was a more important condition that he didn't do, so I'm only going to give him 10%. It leads up to a lot of disparities that way. And then in operational practicality, it doesn't necessarily work, especially with the new language. So if at the midpoint, and I'll give an example. So if at the midpoint review, if we reduce the term because they've completed a few of their conditions of supervision, we have to do paperwork and file a motion to the court. The court has to approve it. And that's the time, and it really doesn't have a lot of impact because once the offender completes the condition, we'd be recommending a discharge. So you have this process that really doesn't have any impact on the offender's sentence, but it will occupy a lot of administrative burden for both the department and the courts, and possibly the state's attorneys and prisoners' rights. On the flip side, if we request a reduction of the probated term and the offender doesn't complete that condition by the end of the new reduced term, we'd have to file a violation to extend the term so they can complete that condition. So it kind of there in practicality it doesn't really work when it's moving forward.
I'm almost confused, but so if you could help me out, Dale. If the person had a 2-year term, they still needed something, wouldn't we be better off to say they'll be reviewed in 6 months or 3 months or whatever, if they are not eligible?
So I don't think we need a set time to review. The way that probation officers will work is they'll be working through the conditions of probation. And with the language that's in there, that as soon as these criteria are met, so it's almost like a review every time we meet the offender or go through the case. So it's not a set time that we would review it. That could actually extend it if we wait every 3 or 6 months. It could be 2 months longer than we actually would need to submit the discharge.
Okay.
If I didn't explain that well, I'll try to maybe do a case that I could walk through that might make more sense. I don't want to confuse.
Well, I am confused. I'm confused.
All right. So I'll do a straightforward example. Let's say an individual has a 2-year term of probation and he has 4 conditions to do. And at the midpoint review, he has completed 3 out of the 4. So the probation officer say, well, let's reduce it 25% because he did 75% of the conditions, and we reduce it by 6 months. All right. Everyone approves that reduction. He now has an 18-month term. Now, if that offender completes all his conditions the following month, we are required to file for a discharge. So that motion to reduce the term was just an administrative burden that really has no impact on the case. Then on the flip side, whenever the offender completes his terms, we would file for a discharge. Unless the offender doesn't complete the required last condition, and we're getting toward the end of the term, the new reduced term, we'd have to file a violation because he's not in compliance with his probation in order to extend the term so the offender can complete the term. Did that add some clarity?
Yep.
Okay.
Yep.
Does it mean that when we file a discharge that the court, when it gets reviewed, if the state's attorney objects, they can make that determination to reduce the term? It should not be on the probation officer. I think that opens up for a few other disparities that I think that the senator was looking to avoid. So that takes care of 2, and kind of 3 as well. It's that same partial reduction of language. On page 7, number 4, the notification of the victims of record, that really is the state's attorney's responsibility. Doesn't mean the department doesn't work with victims, but that is really on the state's attorneys. I think that's a current practice now. In addition, I'm not sure a rule is necessary for this section or for this amendment, because it lays out pretty clearly what the department is supposed to do. The rule would basically just be regurgitating what the statute is laid out. There's not really a lot of decision points for the department to make in a rule. In addition, otherwise we'd have to file an emergency rule and update the rule and go through that process, because rulemaking takes more time than to be effective on July 1st. So the department actually would be recommending to strike number 4, the rule. Any questions?
No, I think it's clearer now for me. By the way, Senator White is not here. She had announced she had to go to Grace Cottage for COVID-19 vaccination. That's where she is. Since she announced it publicly yesterday, I thought I'd be okay to announce it publicly today. Who would like to go next? Maybe anybody? Mr. Attorney General? Assistant Attorney General? Defender General? There's the Assistant Attorney General. Gotta
Morning,
stop
committee.
calling you an Attorney General until you make your current boss a little nervous.
Morning, Senator. You know, I think that I actually defer to some of the other folks on the call who may have more operational input. I think that the draft is moving towards taking care of some of the concerns that we had regarding programming. The definitions look like, in terms of the determinate programming and indeterminate programming, I actually think we're getting towards a solution here in terms of what we're looking for with respect to making sure that people are continuing probation who need to, but there's also the flexibility to make sure we're not holding people past where they need to. I think that some of the other folks who have more granular knowledge on how this stuff works will be more helpful to you at this point in terms of ironing out the language. It sounded like Judge Grierson and Dale Crook already made some good suggestions for tweaks to make it workable, but for now I'll sit back and let some of the other practitioners weigh in on some of the detail aspects of it.
And the overall goal remains to get people off probation and don't need to be on probation.
That's right, and I do support where this is going. I think that the draft is at least in concept is getting towards solving a bunch of the sticking points that we had.
Matt or Pepper, either one of you. Matt, go ahead.
Thanks. I'd like to bring you back, obviously, to start at section 1. Some of this has been brought up, but I think that you end up in a situation with, I'm looking at B, where the defendant is not in compliance with conditions of probation. Sometimes in plea agreements, you end up with surplusage when it comes to conditions of probation that you ultimately, they aren't really relevant to the specific crime, even though the law says that they're supposed to be. And that is something that you end up determining along the way. It's one of these things that defendants get hung up on, conditions that aren't really relevant to their rehabilitation or to the crime. And they may not be in compliance with them. Sometimes there are things like driving conditions or certain types of employment conditions and the like. I don't mind if that is in there, but I would suggest that there be a sub C where the court could find that there's no further need to continue the person on probation. Because the court can look at the facts as a whole and just say, there's not a risk to the public. And while this defendant is not in compliance with all of their conditions of probation, there's no further need to continue this person on probation. And so I would suggest that there be a catch-all that allows the court to discharge people who aren't necessarily fully in compliance, but have met the risk and danger prong of the conditions. One of the things that I think I'd love to have the legislature make a statement on this, which is that probation should not be used for punishment purposes. Probation should be used for rehabilitative, restorative purposes, and focusing on those concepts. If somebody is going to be punished per se, then they're probably going to end up confined somewhere, whether it's a 24-hour curfew or something on probation, or which I've seen on occasion, not very often. It's a little bit of a shame that home confinement went away, but they're going to spend some time in a facility or a work camp or something like that. The concept is to try to get people off probation who don't need to be on, and that we shouldn't be holding people for punishment purposes only on probation. I agree with the discussions that have been had about modifying conditions. A probation deal in a plea agreement is a contract that is has to be upheld by both sides, and if you modify the terms of the contract, then you end up in a situation where a person could withdraw their plea or file post-conviction relief to get the agreement vacated. The conditions could be modified, and are modified somewhat regularly by agreement of the parties.
Senator Benning had a comment or question, Matt.
Yeah, but before you leave page 1, Matt,
Right.
if we added a catch-all subsection C, the line on line 16, we were trying to decide between clear and convincing and a preponderance of the evidence. Does that make a difference if that catch-all phrase is added as to which of those two clauses you'd be happier with?
Well, see, now this is interesting because I hadn't thought of the concept that Senator Sears brought up earlier as conditioning the types of crimes that it would be the subject of this to whether or not one standard or the other applies. So there's that level of it. And now you're asking me about on a different issue. I have a general feeling about this, and I think even reasonable defense lawyers could disagree about this one. Personally, I'd rather have a preponderance standard and exclude a bunch of crimes except for the most serious ones, rather than a clear and convincing standard and I think I said that backwards. I think there's
a robocall in somebody's background. Could they mute?
really wants to know if my auto warranty has expired yet.
Well, if you'd like to testify on Friday about your auto warranty, we're taking up robocalls Friday morning.
I only get 10 calls like that a day. I do have certain glee in picking it up and just hanging it up on them, but in any event, yeah, I mean, I think I would rather exclude, to Senator Sears' earlier point, I'd rather exclude crimes from, limit this to a small number of serious crimes and go with a lower standard. But I can see how people might disagree with that. I think the court, if it wants to come to a conclusion, will make findings of whatever the conclusion it is to get to where they want to get. But if they're prevented from making those decisions regarding what they can consider, then the standard of proof doesn't mean as much. You know what I'm saying?
Yep.
So that's at least on that issue. I don't know if it's a matter of if it could be part of legislative history, but a statement regarding what probation should be.
We can always do a finding, although usually the House does findings. But we can do a finding or a restatement of purpose of probation.
There have been many times over the years where I've had people, and there's actually not in statute any real support for this. You're either on probation or you're discharged from probation. But I've had many cases where they've been on for a period of time. They didn't get everything done, but they aren't causing any more trouble. They aren't committing any more crimes, but they didn't, quote unquote, do everything that we want you to do. And they get, quote unquote, unsatisfactorily discharged. There's actually in statute nothing that says there's such a thing as unsatisfactory discharge. And it may be buried in DOC rules somewhere that I'm not aware of, but this is akin to that, which is basically saying, look, you've done the relevant parts of what we need you to do, and while you haven't complied with everything, we're still going to discharge you because there's no point in carrying you on probation anymore, or you being part of this.
Well, there is a point where you've gotten all you can get.
Exactly. And really what you want is people not to be committing new crimes. And if that is the case, then it doesn't matter what the probation conditions are.
Exactly. I think if Bryn, if we could make some statement regarding probation should not be used, rather than should not be used, probation should not be seen as a punishment, but rather conditions that make positive changes, something like that, for rehabilitation. Or I hate the word rehabilitation now, but I'm thinking of those that all they can get out of the probationary sentence. They may not be successful to you and I, but they've done well.
Yep, I can add a section that does that.
All right. All right, so I'm skipping down to section 2. 252B. Well, it's where obviously where it's, I don't know if you highlighted it or I did, because I have all these notes on the side, but it's basically making decisions between what's going to be included. I'm not against having the department be able to make this work in the manner that is easiest for them to track and make sense with current procedures, so they don't have to be rewriting a bunch of rules. And I'm mindful of what Senator Sears has said about leaving too much to the discretion of a probation officer in determining whether somebody has satisfactorily completed certain programming. What is confusing me, I know what a term probation is, and I know what indeterminate probation is. What I don't understand, honestly, is what determinate programming versus indeterminate programming means, because that's not a term that we particularly use. Are we talking like, AA might be for life. Domestic violence programming, batter's intervention programming might be some number of weeks. I don't know. I don't understand what we're talking about there when we're talking about indeterminate programming versus term type programming. Can anybody is maybe, I don't know if Dale, did Dale introduce that terminology to us? I don't know.
So I don't think that I got that language specifically from any one of the witnesses. That was my attempt to capture what was being talked about with different kinds of programming. Just like you mentioned, there are some types of programs that a person continues on and others that have actually like a 6-month completion date. So that was me trying to capture that. And if there's a better way to do it, I would be glad to.
Yeah, what I don't want to have happen here, this bill is designed to get the vast majority of people off probation that don't need to be on probation any longer by requiring the midpoint review, and I don't want to lose sight of that. And that's the goal here. And I'm afraid sometimes, so I'm as much as possible it should be either completed the I hate the word completed. You participated in the programming you were required to participate in. And Matt, you make a good point that AA is for life. Other treatments are more long-term.
So, all right, maybe we could, there's some way to, maybe that just has to get out of there somehow.
Again, the goal, I mean, I think we need to make sure we don't do things that hinder the goal of the bill, which is to get people off probation that don't need to be on it.
All right. There was, Dale was talking about in sub 3 of this section, the idea that the commissioner filing a motion reduction in term regarding probation, again, and he was, so if there's a I'm trying to get to what this is. If there's a modification at a midpoint review or a denial at a midpoint review, there's going to be reviews down the road. And Dale, I think, suggested that if there wasn't compliance, then the department would have to file a violation, even if the person didn't pose a risk. I wasn't understanding that, because couldn't they file a motion again with the court? First of all, they could always discharge, whether it's satisfactory or not. And they could always request a modification of conditions, which would better suit the person rather than filing, or they could file a violation if one is warranted. So I think there are options besides just filing violations, unless I'm misunderstanding what Dale was trying to get at.
Dale, do you want to comment?
If I'm just trying to think of an example. Let's say someone's taking BIP and they didn't start and enroll in BIP until, let's say, the midpoint review. If we did a reduction of term, they may not complete that programming in time. In order to do that, we would have to extend that term. So they'd be in compliance with their conditions. While if they did have time, once they completed the term, once they completed the BEP or the programming, we would extend that term. So 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 we would extend we would just file a motion to discharge. It's then as an added layer to extend and move the midpoint or the term ending, that really would create confusion, and that really should be on the court's end if they want to reduce the term and not the department making a recommendation. It starts getting really confusing for staff where everyone's going to have a different barometer, where everyone doesn't want individual POs and offices making individual decisions. Some may say that condition is worth 6 months, some may say 3 months, some may say whatever. So I think that whole reduction of term, and then the fact that we have to, that it could be mute out and many options, it just adds burden to the system that doesn't need any more administrative burden added to it.
Okay, so it's not that there aren't things that are doable, it's just there you see an administrative burden. And I get that. I mean, nobody wants to add more to what they're.
But I don't see it providing a benefit. So if I file a motion to reduce the term and then a month later the offender completes the condition that we reduced the term on, then we'd file a discharge to end the term, to end the
You have
probation.
concern about this in counties, particularly where there's a lack of availability of services. So, you know, the BIP program only comes up so often, or, I mean, is that where you're seeing this being a big issue? I'm just trying to understand. Because you might get on probation and then the next program doesn't start for, you can't get in it for 6 months. And so that nobody's they're not in compliance, but they are unable to access the service that they need.
There could be many reasons why they don't complete. Maybe someone has 3 different types of conditions and they can only do one condition at a time, and it just takes them longer to have it completed because they're working and doing other things. So it's really, you know, what the goal is, I think, is once someone completes their conditions, as an incentive, we want to discharge them from probation. And I think that's where we want our time focused on.
Yeah, we basically don't want people doing effectively dead time on probation, with just being on probation with nothing left to do. Okay. For me, I guess the only other thing to talk about is, what crimes might be on the list to be excluded, and again, I would obviously prefer there be a shorter list and a preponderance standard for burden of proof. It's always one of those ones. I think it's because of the words that are used. Lewd and lascivious conduct with a child was one that was, I think, proposed to still be on the air, even though sexual assault on a minor involving 2 individuals who were of similar age was not going to be on the list. But that same period of time applies to L&L with a child as well. So if you're going to do sexual assault consensual between minors, then you should do the same thing with, exclude that from not being able to do this. Then you should do the same thing with the L&L with a child under the same circumstances. I think that's all I have, but I'm sure I'll think of other things as this evolves.
Yeah. How do you deal with split sentences? I'm thinking of those types of crimes.
Well, I mean, that's a very common thing. So, they're going to end up doing time, whatever it is, and then they're going to have some amount of their sentence that is going to be, as you said, split to serve on probation. And I think you just look at it halfway through whatever that term is.
All right.
So, I mean, if you're doing, 2 to 10, all suspended on probation, except for 2 to serve, then you're probably going to look at them at 5 years and see where they're at.
Well, I think you could eliminate anybody who's on lifetime supervision. That would be
Anybody who has an indeterminate life sentence might be one, again, except for, to me, those that have the consensual element of minors in the sex cases. There's that other group that just says until further order of the court, which in theory could be life, but is not an indeterminate life sentence by statute.
okay. Thanks, Matt. Who's like to go next? Whoever would like to comment? Maybe Pepper.
Sure. Thank you. For the record, James Pepper, Department of State's Attorneys and Sheriffs. I think this bill, again, is moving in the right direction. It sounds to me like all of the people that have spoken today and have spoken offline are in agreement with the underlying principle that the midpoint review should be strengthened, and that people that no longer need the kind of supervision of the court should be removed from probation. We have, I think I should just focus mostly on section 1, because it sounds like section 2, there's general agreement, but there needs to be some kind of cleanup or clarification in some of those sections that I think, we're all pulling in the same direction there. But with respect to the first section, and this is when, there's been a motion filed by corrections and it's now within the court process. I would agree with Judge Grierson that, it should be the state that's seeking a continuation of probation, not the Commissioner of Corrections. I would agree with Matt Valerio that I think the state's attorneys would prefer the preponderance of the evidence standard here, with and having the exclusions apply to fewer crimes. Because I think that what we have mostly been concerned about are the supervision conditions that are related to victim safety and victim harassment, victim contact. And so if that's an issue, I would want the court to have the ability to not have to face, I would not want the court to be faced with a decision where they must discharge because there wasn't clear and convincing evidence of a victim issue. But I would like them to go down to that second part of section 1, which is, this is a good opportunity to review and modify the conditions and maybe get rid of the, no ignition interlock, maybe get rid of the curfew or some of the other conditions that aren't really related to victims, or reduce the term. And so that's why we would prefer the preponderance standard here.
Senator Sears?
Yeah.
James, Matt had suggested a catch-all phrase, basically allowing the court to make another determination altogether, but that would also, if we plug that in here, you understand with a preponderance of the evidence standard, that standard would apply to that catch-all phrase as well.
So I wasn't, I hadn't considered the catch-all phrase until Matt Valerio just brought it up. I don't believe that the state's attorneys would support that catch-all phrase right there, mostly because what he was saying is that compliance with conditions should not be a prerequisite for discharge. And compliance with conditions, I think when you're out on probation, you're kind of on a trial period with the court. And if you're not complying with your conditions, then I think that should indicate that maybe discharge isn't appropriate at this time. And, when Matt suggested that some conditions aren't relevant to the crime, I work in my summers and, in the appellate division of we frequently are litigating cases about conditions there not being a nexus to the crime, and they're dropped very frequently. So there is a remedy for folks that have, overbroad conditions or conditions that don't.
Let me give you an example. If one of the standard conditions of probations is that you meet with your probation officer when and where as directed. And if there was a planned meeting with the probation officer that was missed, the offense of that did not rise to the level of the probation officer deciding to file a violation. But technically, the probationer is not in compliance with what has been suggested. And the way these two provisions, A and B, are right now, as I read them, if he's not in compliance with conditions of probation, B would knock him out of being eligible for this remedy.
Sorry.
Well, I see Matt's suggestion of a catch-all phrase that a court could look at and say, they've done what we really wanted them to do. They may not technically be in compliance as a result of having missed this particular meeting, but why are we going to keep them on probation? And I saw the wisdom in Matt's suggestion. I understand you're objecting to it. I'm throwing you back that example as something that I could foresee being used to deny somebody in this circumstance.
Well, so the denial that would occur if you added a subsection C would be just related to discharge. So a person that the individual that you're discussing would still have a remedy here in that there could be a decision by the court not to discharge, but to reduce and modify. And I know that there's some concerns around the term modification, and there should be some clarification because, again, we're all on the same page here that this should be a reduction of either the term or the conditions or both. But that if someone is not compliant with their conditions, I think that should indicate that maybe discharge is not appropriate, but that a modification could be appropriate, and that would still be allowed under subsection 2. So it's just one of those disagreements that I think that we have, that a modification is likely appropriate if potentially someone is not compliant with their conditions, and of course it depends on what those conditions are. But that this bill allows an avenue towards a significant reduction or a modification of terms, even for those folks that are not compliant with conditions.
Seems to me, reading it, that they would still be denied the ability to get off probation under those circumstances if we left it the way it is. Court doesn't have an option. They can modify the conditions, but they're still not eligible for getting off probation at that point.
If they're not compliant, right?
Yeah, and if they're not compliant with a standard condition of meeting with their probation officer when and where as directed, I can see that being a snag under the way this is currently worded.
Well, Bryn,
Can I weigh in here for a minute?
please.
If we change that language in subdivision B on the top of page 2 to tie it more closely to the language in the second section about that programming, then the language won't be in compliance with conditions of probation. It will actually be more specifically tied to their programming. And so would that solve the problem here? Or
It helps. For some reason, I keep going back to one individual who became infamous and led to Act 1 in 2010 or 11. It might have been 2009. Doesn't matter. Act 1 was following the murder of Brooke Bennett, and the evidence that we gathered about Michael Jakes on probation would lead me to believe that whatever we do There, the individual probation officer decided not to violate because he didn't recognize the red flags that were being thrown up there. The guy had gone out of state when he wasn't supposed to, White River Junction, whatever that, Lebanon, Vermont, Lebanon, New Hampshire, or whatever it was. There were a lot of red flags, and I think as much as possible, we want to leave the discretion to the court, but not just another thing I get uncomfortable with here.
Dick, I agree with your lack of comfort in the case of a worst case scenario. But it's a pretty standard thing in my business for somebody on probation to miss a meeting with their probation officer. And that's one of the standard conditions of probation. So everybody's going to have that responsibility. And as I read it right now, if they're going to be released at the midpoint, the only way that can happen is if they are in compliance with the conditions of probation. So technically they're not. And I'm thinking that the court ought to have some kind of an override where it sees that the infraction is really de minimis and we don't keep them on probation simply because they may have missed an appointment and a probation officer hasn't deemed that a violation of probation.
Sir, if I may, this is
Yep.
But understand, the decision, we're not concerned. I'm just trying to give information that the department will not file the discharge if they've been found in violation by the court within the previous 6 months. So the situation that Senator Benning is talking about, unless we file a violation in court and the judge upholds that violation, then we would be submitting a discharge. As far as what language you use is not a concern. It's just trying to help the committee by understanding that you have to be in no violations for 6 months before we even file the discharge.
Well, Dale, the way that I read this now, the intent is to get somebody off of probation at the midpoint. Unless the court finds one of these two things. Now, if the court asks the question, has the defendant complied with his conditions that require him to meet with a probation officer? Even if the probation officer has not filed a violation, the probation officer, assuming they're telling the truth, would say, well, they've made 6 out of 10 planned meetings. Is that person in compliance with conditions of probation? I would submit it doesn't sound like it to me. And I don't want that to be a hang up if probation has never decided that that alone was worthy of a violation to be filed. So I'm thinking that the catch-all provision that Matt was suggesting made some sense to me, and I'm going to leave it at that.
If you don't mind,
No, I don't.
The ones that I am wary of are conditions that you maintain stable employment or stable housing. And while the person may not be committing any crimes and they might be doing their programming, they may also, in the course of a year, change houses some number of times, and they may lose their job through no fault of their own, or end up changing jobs, or that kind of thing. And so it's the kind of the stability of the things that are outside of your control that may give rise to questions about compliance that are not even something is like maintaining a phone or something. Those types of things concern me, and what Senator Benning was talking about is another typical kind of thing, making all your meetings, that sort of thing. To me, as long as you are not committing crimes and that you are attending you've done your programming, some of these other things that are difficult for even people who are not on probation, if you are on the lower economic rungs of our society, they should not be the thing that keeps you on probation.
How about a word like, how about defendant is not in substantial compliance with conditions of probation?
Senator, if I may throw in a suggestion that hopefully is helpful and not.
Yeah.
Looking at the way the mechanism is working, as I see it, is basically the way the court gets these is through a recommendation from the commissioner. And so what we're really arguing about, and we could change that mechanism, but the way the statute is currently set up, that's the concept here. And so you have to go down to page 5 and 6 to see what are the triggering things that are going to send this, that the commission, that is going to require the commissioner to send this to the court. And so there's two, well, one important point that I think Dale was making, which is that I read subdivision A at the very top of page 6 to be limited only to those cases where there was a VOP that somebody was adjudicated in court for a violation of probation. So not that somebody was not in compliance and the department knows about that, they didn't show up to a meeting, they were having trouble maintaining housing, but that there had been a violation of probation filed with a court and an adjudication of guilt found on that, which is quite a bit different, I think, than the sort of, and a higher bar, and frankly, policy-wise good, because that limits the discretion of the department and means that more of these cases are going to be going to the court. So I think that we're talking about a fairly limited issue here, and that it's only if the VOP has been filed and adjudicated guilty by a court. There already was a judge who had to have said you're in violation, not just that a probation officer thinks that they're in violation before. And so unless that pretty serious process has been fulfilled with some serious due process protections, this is going to be filed with the court as long as the other two, B and C, have also been met. The other thing I would suggest, and I realize the department may not be okay with this, but I'll throw it out there as a suggestion, is another additional protection you could have is to basically say, hey, if you meet the conditions of D1, which is contained on pages 5 and 6, the thing shall be filed. But under subsection 2, you could still give the court, you could give the commissioner the discretion to say, you could request the reduction in term of probation or request dismissal. So basically it's like D1 is a shall, you meet those conditions, you get the recommendation, and then the court checks it according to the things on page 1 and 2, or you don't meet the conditions of D1, it's no longer a shall, but the commissioner still has the discretion to say, well, that VOP we filed was adjudicated 5.5 months ago, there's been no issues. Technically they don't meet D1, but this still gives the discretion to say you can either reduce the term or discharge. So those are a couple thoughts that I have on that issue, hopefully productive. Oh, maybe not.
No, I think so. Anybody else who'd like to speak that hasn't so far? The network is here, Chris Fenno's here. We haven't heard from them, and we haven't heard from Monica, if she has anything to add. Chris, join
Yes.
us.
For the record, Chris Fenno from the Vermont Center for Crime Victim Services. Very interesting conversation so far. And I would say that the things that are being suggested are ones that we would support. Again, going back to that issue about clear and convincing or preponderance, we fall on the preponderance side. That dealing with risk to the public is an important thing. And so that needs to be clear that the defendant does not pose a risk. In terms of the modification, just wondering, I agree, a couple people have spoken today and the other day, that the subjective nature of a probation officer is, I think, confusing to trying to get fairness across the board. So I would suggest sort of meaningful, measurable, and specific criteria to be used. For instance, and we've talked about this too, completed programming. Take out that piece of successful. We're in favor of that. And then finally, and I didn't have time to look this up, but I'm sure somewhere in statute, there is a definition of good faith effort. And my concern is that good faith effort looks different from one place to another. And just to make sure that there are sort of parameters around what that means. And those really are our only concerns at this point.
Thank you. Any questions for Chris? Thank you. Jessica? Hi.
Hi, all. Thanks for having me. Jessica Barquist from the Vermont Network Against Domestic and Sexual Violence. And I will just agree with many who have come before me and say that I think this bill is headed in the right direction. And we definitely support many of the changes that have been made. I support the added language that strengthens the victim notification. I think that is really important. And like Chris and others have said before, I would also support the preponderance standard and excluding more of the crimes from the carve out than the clear and convincing standard. So thank you so much for taking the time to make these changes.
Thank you. Anybody else who wants to comment before we take a break? One thing I'd like to consider adding is many states cap probation for misdemeanors at 2 years. Alabama, Georgia, Hawaii, Indiana, Illinois, Iowa, Kansas, Kentucky, Louisiana, the list goes on, New Hampshire, Delaware, Indiana, and Maine cap it at 1 year for misdemeanors. I'm wondering if we were able to put a section in and ask for a report from the Sentencing Commission to Justice Oversight recommendation about whether Vermont should cap probation for misdemeanors.
Makes sense to me.
At the same time as this was being done, as this bill was being drafted, there was a Pew study, December 2020, regarding a number of things regarding probation. And we're in pretty well in good company, but we have indeterminate probation terms even for misdemeanors. And we're only with Florida, Massachusetts, South Dakota, and Virginia in that category. I don't want to get into felony right now. That gets a little more complex. Anything else before we take a break?
Yeah, well, one more thing, sir. This
Yes,
is,
sir.
Joe Kerr from the department. We did hear what the network said and the other issues. The concern is still with the good faith effort being placed on the department. That would be an added responsibility. Our victim service specialists, we currently have 3 in the department, and their primary function is to work with offenders being released with the victims to make sure that there's safety plans and notifications going out when our offenders are released. We do believe that the victim should be notified, but this responsibility currently lies with the state's attorneys, and we would like to suggest that it remains with the state's attorneys at this point.
Okay. All right. When we get back, we're going to take up S18, which is the earned time bill, and then come back to this at 11:30. We may not be ready to vote, but If we are, great. If we aren't, okay. We may need to chat a little more amongst ourselves. But Eric is, Peggy has posted a redraft of S18, the earned time bill, and on the committee page. And Chris Fenno has a statement on that as well. Look at it. We'll be back at 10:45, and we're going to end the live stream. But those who are watching on YouTube can catch us back at 10:45. Thank you. So we need to stop our video and mute.
Yeah, ideally, still better to do that, but we will be stopping the live stream, so. And I'm going to put the break up so people know what happened there. Share screen.